Episode 4, How to Challenge a Suspicious Will in Court, and the Signs of Fraud, Undue Influence, or Forgery. Welcome to Episode 4 of Wills, Inheritance, and Family Property Disputes in Nigeria. Today, we are diving into a sensitive but important issue. What can you do if you suspect that a will is not genuine? Whether it's because someone was pressured, tricked, or the will was outright forged, Nigerian law provides ways to challenge such a will in court. But you must know the signs, the grounds, and the legal process. 1. Who can challenge a will? Not everyone can walk into court and oppose a will. To challenge a will in Nigeria, you must have an interest in the estate, such as a family member or legal beneficiary who was excluded, a spouse or child who was unfairly treated, a person who suspects fraud or manipulation. 2. Grounds for challenging a will. Here are the common legal grounds to challenge a will in Nigerian courts. A. Lack of mental capacity. If the testator, the person who made the will, was not of sound mind when they signed the will, due to illness, dementia, or mental disorder, the will can be declared invalid. B. Undue influence. If someone close to the testator, like a caregiver or relative, pressured or manipulated the testator into giving them property, that's undue influence. Example: a second wife manipulates an elderly man to leave everything to her alone. C. Fraud or forgery. Was the signature faked? Were the contents changed after the testator signed it? Was an entirely new will forged? Courts take such claims seriously, but you must bring proof. D. Improper execution. The will was not properly signed or witnessed according to the Wills Act. If only one witness signed, or the testator didn't sign at all, it is invalid. 3. Red flags, signs of a suspicious will. Look out for these warning signs. Sudden change in beneficiaries, especially close to the testator's death. A beneficiary who also signed as a witness. A will typed or written by someone who gains a lot from it. No one in the family knew the testator made a will. Missing pages, corrections, or vague language. 4. How to challenge the will in court. If you suspect any of the above, go to the probate registry in the state where the testator lived. File a caveat. This stops the will from being executed. You may then file a summons or originating summons to begin legal proceedings. Evidence is key. Medical reports, handwriting experts, witnesses. Important, time is critical. Don't wait too long, especially once the probate process starts. 5. What happens if the challenge succeeds? If the court agrees that the will is invalid, the estate will be shared according to customary law or the administration of estates law. A new administrator may be appointed by the court. Conclusion: challenging a will is not about greed, it's about justice when there's clear evidence of wrongdoing. The Nigerian legal system has safeguards, but the burden is on the person challenging the will to prove their case. Thanks for watching Legal Guide TV, where we break down Nigerian law in simple, everyday language. If you found this helpful, don't forget to like, share, and subscribe. Tap the notification bell so you won't miss our next episode. And if you have questions or a legal topic you want us to explain, drop it in the comments below. Let's learn the law together, the right way, the Legal Guide way. See you in our next episode.